the most important players in this procedure are the bondholders of the city of Vallejo, the ones in New York. And they're going to have a significant involvement in this process. Everybody's going to have, including citizens. You have the right as a citizen to speak to the bankruptcy court. And that's a very unusual departure in bankruptcy. I can just imagine a designated judge hearing some of the people who appeared at city council in the manner they've appeared, giving them their thoughts. So perhaps instead of having a one-by-one basis, may I suggest that at this time there be an organized effort, a citizens committee who will study this process, who will formulate recommendations, because as a designated committee, I think you'll have a greater ear before the bankruptcy judge. I think he'll listen to somebody who comes forward in a meaningful manner and is intelligent and articulate about what impact this is having upon us. But as soon as that case is filed and that restraining order issues, we're in Chapter 9. It doesn't disappear. The counter move by anybody who doesn't like the filing of a Chapter 9 is to test the reason why it was filed. And they do that on good faith. And most likely they will file a motion to dismiss alleging that, number one, the city was not insolvent, or number two, they did not bargain with the proper people in good faith prior to the date of filing. And that has been successful in a couple of cases. It was successful in the San Jose Unified School District, where they did attempt to reduce salaries to teachers. And while they were talking about it in the courtroom, the unions and the city got together, talked about it, and finally came to terms. So the case was dismissed. But a motion to dismiss from anyone, particularly union leaders, will test whether or not the bargaining and all the discussions that have been going on for the last several weeks was fair and proper and open, or was it a bunch of charades? Because if the judge is convinced that this was not a fair attempt, a reasonable attempt to resolve our differences before we entered this realm, he'll throw the case out on our ears. It'll be that fast. Now, when a case gets dismissed, it's time in again. We're right back to where we are this moment. We have all the raises staring us in the face. We have all the unpaid obligations that we have to look at. We have the deficits we have to look at. So it's time in again. That's all that can happen. One of the rumors I've heard throughout the city is they're going to force us to sell our assets. They can't do that in a Chapter 9. And the reason for that is that a city is a subdivision of a state, and the 10th Amendment of the United States Constitution says the states have certain powers. They have sovereignty. They're part of the king. And you cannot just throw out a Chapter 9 because of that position. Now, the state can come in, as they did in San Jose, and they can appoint a trustee or a receiver, just as occurred with the school district. And that trustee then takes over the functions of decision-making that the city council makes. But that's up to the legislature. It's not a slam dunk, and it has to go through the legislative process. So before that takes place, most probably, the legislature will decide who their friends are and whether or not they want to intervene in this process, and I'm sure the governor will have something to say about it also. But that's the number one reaction upon the filing of the case will be a motion to dismiss. It'll almost be automatic. The only other thing the judge really gets to do is decide whether or not to approve the plan. This is a readjustment of debts. You have to tell people, how are you going to pay for these obligations? Are we going to delay, defer, or deny the payments? Because that's the only three things you can really do with a debt. And in this emergency financial plan that has been proposed by staff, touches on all of those. We're going to defer payment of some of these obligations. We're going to delay the increasing of the raises. We're going to have the redevelopment agency pay for some of these monies. Well, the staff report has touched on all three abilities to delay the filing of the Chapter 9. And if a Chapter 9 can be delayed, then there is no reason to file it, because you can always file one of these things. Council, I understand, has already been retained by the city, or at least advising them. And the way petitions get filed in the Eastern District of California is we electronically file them. We put them on our computer and we ship them off to the bankruptcy court, and it gets filed electronically. And that's true whether the bankruptcy court happens to be open at midnight or whether it's 9 o'clock on a Monday morning. As soon as it's filed, the restraining order comes into effect and we're off and running. Now, some of the other differences that occur in a Chapter 9 compared to a traditional type of bankruptcy that you may have heard about. There's no meeting of creditors. In a normal bankruptcy, everybody goes to court about a month afterwards, and there's a trustee who asks questions and checks out assets and finds out background. That doesn't take place in a Chapter 9 because you can't infringe upon the power of the king, and that is the city. There's no United States trustee involvement as there is in a business reorganization. They get paid for being involved. They're the watchdog of the bankruptcy world. And in a Chapter 9, all they can really do is monitor to find out whether or not the forms are being filed. There's no ability to seek directions from the court as there is in a Chapter 11. There are no reporting requirements in a Chapter 9 as there are in Chapter 7s and Chapter 11s and, Chapter 13s. The city council, or the trustee if it takes over, remains in place. The court cannot step in and control the political process. It can't control taxes. It can't control revenue. So there's a huge amount of autonomy that remains in the city when it files a Chapter 9. Now, the state might step in, but that remains to be seen. Eventually, this plan has to be presented. How are we going to deal with these debts? And this plan does get to be voted upon by creditors. And you have to have approval of your creditors as to a majority. But one of the other big distinctions in a Chapter 9 compared to a Chapter 11 is that if the judge feels that it's in the best interest of the creditors to have this plan approved, even though the creditors are not approving it, the judge has that power to approve it. It's called a cram down. And the best interest of the creditors in Chapter 9 is considerably different than it is in any other area of bankruptcy. It's what is the best possible result that can be reached given the circumstances. And that's the judgment call that the judge makes. And this is where they bring in good faith again. They're going to look very heavily at how every side has handled their negotiations with each other. They're going to test their belief of what should have been done, what could have been done. They don't have the power to come back and say you must raise taxes. But they do have the power to come back and say, well, I think it would be good in good faith if you considered that. And I'm going to delay the hearing for a month while you think about that. And of course, you know, bankruptcy can go on for a long period of time. If a plan gets approved, that's when the reorganization takes place. You've probably heard the phrase, they emerged from bankruptcy today. Well, that doesn't mean the case is no longer before the court. It means that their proposal has been approved. And it's the approval of the plan that reestablishes the debt. Either it's going to take longer to pay it, you're going to pay them a lower interest rate, you're going to pay them a lower percentage, you're not going to pay them at all, which is what happens to stockholders when a corporation goes Chapter 11. Or you're going to accept payment of this instead of that, you're going to receive this asset instead of that asset. Where unions are concerned, they have a collective bargaining agreement. And the nullification of the enforcement of the contract is what takes place upon filing. It's not the nullification of the contract itself. Now, in Chapter 11, you've got to go through hoops to get that done. And the reason for that is many years ago, there was a case that was filed by Bledisco. They filed Chapter 11 because they couldn't get along with all their union contracts. They were just too expensive for them. Well, the unions filed a grievance before the NLRB, said this is an unfair labor practice. Sounds familiar. And then the two cases got combined and worked their way up to the United States Supreme Court. The United States Supreme Court said, yeah, you can nullify labor contracts by the filing of Chapter 11. Well, the unions had their friends in Congress. They went to Congress and they got a new bill passed. But it only applies in Chapter 11. Chapter 11, it's Section 1113. And that says when you file a Chapter 11 bankruptcy, you have to ask the court to approve the rejections of the contract. Now, when they rewrote Chapter 9 a couple of years ago, and then again they modified it in 1994 when they added more judges, they've never included that Section 1113 into Chapter 9. It's not there. There's a lot of discussion amongst scholars and law professors and commentators about whether or not this means you can reject a union contract. The true answer is we don't truly know. The indication is that it looks like we can. We can nullify it, and that there is no